just pause you there? I think for the live feed, sorry, they're not able to hear without the microphones, is that? They can't hear. So
Okay.
Try our best, although I appreciate the acoustics aren't ideal for
Not at all. If with the echoes you want me to repeat a question, please tell me, Mr. Kirkpatrick.
Thank you.
Right, so we've narrowed it down to it's people are the receptors that are being dominated. Where are you saying the inspector shall go? Assessing the visual impact of the proposed development, and he will experience, were he to in his mind's eye imagine the development in place, a dominating effect of the proposal. Which viewpoint?
I would go to the 4C montage from the country park.
From the country park?
It's the Little Venice Country Park from Hampstead Road. That's viewpoint 4C, supported by a photo montage.
So if we look at your viewpoints, your appeal site appraisal photographic viewpoints, which are labelled A to H. And I'm only taking to that because it's a convenient way to say whereabouts are you saying the inspector will stand and have a dominating effect of the proposals? Where is it?
I'm referring to photograph K.
Yep.
And we can see the appeal site polytunnels that are annotated, and the photomontages illustrate the visual mass of the built form. And the case that I've put forward is that the parameters associated with the appeal scheme would result in a development where built form would be a dominant component of the scheme, a more dominant component compared to the allocation proposals.
Well, you've beautifully slotted in what's the obvious point in relation to the to a view from that distance. So just to be clear, therefore, when I am to look at the reason for refusal and ask where will there be a dominant effect, you would invite the inspector to go to the Little Venice Country Park, and you would say that the proposed development, in that viewpoint, the inspector will see the difference between that and an allocation-friendly development in the way that's been put by my learned friend, would have a dominating effect, but the allocation wouldn't. Is that your case?
A more dominating effect. I think, I hope I was clear in my proof that there will be landscape and visual harm arising from the allocations. That is recognised. The issue, as I think it's common to both proofs of evidence, the issue is what is the effects of increasing the density and numbers of built development and the harm that would arise from that. And my point was it is more dominating for reasons that I set out earlier.
You see, the only part I can find anywhere in your evidence which even discusses this is in relation to views from Kenward Road at paragraph 8.5.5. And you'll appreciate I'm looking for the word dominant and indeed dominate because it's part of the reason for refusal. So until I asked you a moment or two ago, whereabouts in your evidence had you identified that there will be a dominant effect upon a viewer in the Little Venice Country Park?
I've not used the word dominant.
And save for telling us that views from the west along Kenward Road would involve the new housing truncating and dominating that view, where else have you addressed this part of the reason for refusal?
I don't recall any other point.
Can we agree that the effect of the appeal proposals, forgive me, the appeal site being developed for 100 houses would have an urbanising effect upon the appeal site, which would be evident.
A dominating effect on the appeal site?
No.
Yes, we can agree that.
Dominating effects on the appeal site, good. Can we agree that the development of the appeal site for 100 houses would also have an urbanising effect upon the appeal site?
Yes. But I would caveat that, as I said earlier, it is a question of degree. So is it more dominating and more urbanising?
So if you were writing this reason for refusal, you wouldn't be saying that the appeal proposals have an unacceptable dominant and urbanising effect. You would say it would have a more dominant and more urbanising effect. Is that right? Compared to what the allocation does.
I probably would, yes.
Yeah. Thank you, that's helpful. 8.5.17, just in the basics at the moment. 8.5.17, you tell us that you share many of Mr. Radnall's concerns. And Mr. Radnall's assessment is at core document 13.1 for the inspector.
My apologies, could you repeat the reference again?
8.5.17, I think it is.
Okay, thank you.
Yeah. I share many of the concerns expressed in the LVA review undertaken on behalf of the council by Peter Radnall, who would have been sitting in your position had he not been elsewhere. You enigmatically don't tell us which of his concerns you share and whether you take issue with the remainder of his evidence. Can I take it that if you took issue with Mr. Radnall's assessment, you would have said so?
I think some of the concerns I agreed with, and others I didn't feel were of great consequence to the appeal.
Okay. So where Mr. Radnall has made a point of consequence, you agree with him, and where he's not made a point of consequence, you're not worried about it because it's got no real impact on the outcome of the appeal. Is that the point?
Broadly, insofar as those are my view of the consequence, yes.
Can you turn to court document 13.1, please?
CD 13.1?
13.1. Which is a 12-page document on the PDF, when the PDF is running 2 pages in advance of the numbers on the bottom of the pages. And when you get to it, I want to turn you to paragraph 5.1, page 11, and 5.3, page 12.
Okay, I'm now at 5.1.
Yep. So 5.1, Mr. Radnall tells us that the LVA has been carried out in accordance with the principles of GLIVIA. It's well presented, compliant with the main aspects of good practice, and then sets out some bullet points. And then 5.3, the council are therefore advised to form their own judgment about the acceptability of the proposals in landscape and visual terms. The judgment should be informed by the factual information in the LVA and elsewhere, by the comments in this review in order to gauge degree of compliance with the relevant policy tests. So it's a basis upon which Mr. Radnall invites decision making, and he tells us that it's a well-presented report which is compliant with the main principles of Glivia. Why don't you tell us that, Mr. Kirkpatrick?
I think that I've got some concerns about the LVA insofar as it doesn't tease out the sensitivities of the local landscape or guide the development to a more appropriate scheme.
I'm sorry, Mr. Kirkpatrick. I wasn't asking you whether you had concerns about the LVA, because, as I said, enigmatically, all you say is you share many of the concerns expressed in the LVA review by Mr. Radnall. Mr. Radnall, instructed by the council, who would have been sitting in your position but for an accident of history, tells us that he concludes that the LVA has been carried out in accordance with the principles of Glivia, well-presented compliance with the main aspects of good practice, and at the end, council are advised to form their own judgment based upon ... the information in the LVA. Why don't you report that, even if it's to report it and then disagree with it? Why don't you tell the inspector, consistent with your professional duty, Mr. Kirkpatrick?
I haven't repeated this insofar as it's obviously it's a core document and it's there to be read.
Yeah. Why haven't you drawn attention to the fact that the LVA was audited by Mr. Radnall, who concluded that it was a document which conformed to the guidance? Why haven't you done it?
Because it's in the statement of case and it struck me as self-evident.
Not that it's unhelpful to your case, then?
No.
It's a relevant factor for the inspector to have in mind, isn't it? That the council had this document audited and concluded it was compliant with Glivia, or the main aspects of Glivia, and was a proper basis upon which to form a judgment. It's a relevant factor for the inspector to be mindful of that.
Yes.
Thank you. It doesn't say anywhere in it, does it, that the parameters plan should be revised so as to move some of the peripheral landscaping about, does it?
No.
It doesn't say that the additional extra density of the proposed development compared to the policy is problematical, does it?
No.
It doesn't say that he, Mr. Radnall, thinks that this is not a settlement edge site, does it?
It does not.
It doesn't say there's a need for a formal ZTV, does it?
So I'm just checking. He assumes that a ZTV has been produced. I'm not sure that it would appear to me that I've seen no evidence that a digital ZTV has been produced as opposed to a field survey assessment, and I don't think Mr. Admiral has come to a conclusion on that.
Yeah, he actually points out that it hasn't yet been produced in section 1. It says it at the top of page 5 of the PDF. Visual material has not to date included ZTV. Should also be reiterated that the visual material zone of ZTV has not to date been subject to technical audit, etc. Obviously, if it's not being produced. Where was the request for a formal ZTV before your proof? I.e., at a time my clients could do anything about it.
Sorry, could you repeat the paragraph, please, in Mr. Admiral's where he makes that statement?
Top of page 5 of the PDF, and note that you're on the computer, page 3 of the electronic version. Visual material supports the LVA. ZTV, photography and montages, has not to date been subject to an independent technical audit. Should be reiterated, ... have not been subject to a technical audit. So he's not seen as ZTV, because it's not been subject to a technical audit by him.
Okay, so no, there's been no technical audit of it. And I think Mr. Williams' point was that would be that none had been requested and it wouldn't be appropriate to do so.
Yeah. My question is, the material you produce at page 32 of your proof of evidence, the visual mapping based on a single point source at 9.5 metres height, which you say, well, had this been done at an earlier stage, it would have revealed a problem. We don't think it would, but I'll come back to that in a moment. When has this information been requested? Before your proof?
To my knowledge, there was no request for additional ZTV information.
You may gather as we move through this that part of the thread of my cross-examination will be so what. So I'm very keen on understanding what knowledge this document provides to me. When I look at this, it's showing me where a single point at 9.5 metres in height, so the top of the ridge line of a house in the middle of the site, where it would theoretically be visible from, yes?
Correct.
That would be as true for the allocation as it would for 100 units as it would be for 112, wouldn't it?
That's correct.
So in terms of the differential between 100 and 112 units on the site, this tells me precisely nothing, does it?
I don't agree. I think that what it demonstrates is that the zone of visual influence as set out in the LVA has not been correctly identified. With regard to the so what question, what this digital visibility mapping brings is an understanding of the extent of the harm, and that maybe would apply to the, as you suggest, the allocation side, to the proposed allocation, but also the additional harm that would arise from the appeal scheme through increased density and numbers.
Let's think about that, shall we? Let's think about views from the south, because this shows lots of views from the south. If I'm looking towards the appeal site with houses built on it, 100 houses built on it, I'm looking at the flat elevations, aren't I?
Looking at a flat?
I'm looking at the flat elevations of the front.
Correct. Yes.
The elevation that's facing me, yeah? Mm-hmm. If I was in a helicopter, I would be able to see the layouts and see the space between the houses. But if I'm looking from the south, I'm looking at built form behind built form behind built form, aren't I?
You're looking at, to a degree, layers of built form as you go up the slope, but it is a planar view. But the point that I was making earlier is that it's not just a question of the visual impact of the built form itself. It is the interrelationship and interplay of buildings and vegetation. And that's the issue that I've endeavoured to tease out in my proof, where that there are, in my opinion, greater opportunities for inserting green space within the development such that it doesn't become planar, it's more broken up. You see vegetation in depth, and the opportunity of indented green space along the western edge means that it's less of that planar view that you described.
But I would still be seeing it in planar view, wouldn't I? Planar view.
You would, but with some depth to it.
Providing that depth was higher than the houses between. Otherwise, I would be just looking at house behind house, yeah? Because I'm looking horizontally at these houses.
Yes, but you should be able to appreciate that some houses are set back further from the site boundary than others if there is that depth provided.
So just to think about where you were telling me to go to Little Venice Country Park, where the proposed development will have a more dominating effect upon the viewer. Your case is the inspector will stand at Little Venice Country Park and should be able to appreciate that the effect of 112 units will give rise to a perceptibly denser form and more harmful form of development than the effect of 100 units. Is that your professional judgment? And I want to be clear about it because I want to make comments about that the nature of your judgment in closing, you're saying the inspector will be able to judge that?
It should be possible to pick up that difference, yes.
Should be possible.
If so, it depends on how the scheme is designed and what the parameters are. My point was that with a different parameter plan, then you would be able to make that difference.
So the height of your case for the location where there's a dominating effect, a more dominating effect, forgive me, is it should be possible to judge that change. That's
Yes.
the height of your case, is it?
It's not the height of my case, but it is a point.
Well, forgive me, on the scale of it will definitely be perceptible down to it will be imperceptible, you're putting at the it should be possible end of the spectrum.
It will be perceptible.
It will be perceptible. So it's no longer should be possible, it will be perceptible. So the height of your case is perceptibility, is it? Because the reason for refusal tells me it's dominating this change. You see the problem here, Mr. Kirkpatrick, I assume. I'd suggest to you, you won't be able to tell a difference. But even if you could tell a difference, your case isn't just perceiving a difference, your case is perceiving a difference to such an extent that it's a more dominating impact. You're nowhere near that, are you, in that location?
At that location, I think the difference would be perceptible, and hence it would be more dominating than the allocation proposals.
Good. Let's have a look, please, if we can, at the parameters plan, which I will return to in a moment, but I want to be as clear as I possibly can be. So I'm looking at the proposed parameters plan. It should be drawing number 201.
I have a parameters plan, yes.
Good. Let's see what we agree and disagree in relation to. Site B. So everything in the rectangular area south of Kenward Road. You have no difficulty with that area, do you?
No.
Indeed, it's a positive adjunct to the townscape to have that publicly available, isn't it?
As a new accessible public space, it is.
A large public resource immediately behind Oast Court, which will be available for future and existing residents. That's a tick in the box in the townscape terms, isn't it?
It is.
Good. The area which has the little blue star on, that's the area of the sustainable urban drainage. Also an area which, unless it's got water in it, will be publicly accessible and publicly available, wouldn't it?
It would.
But it would be undeveloped, wouldn't it?
It would have no built form on it.
Yeah. Your concerns relate to everything on the northern side of Kenward Road, yeah?
Correct.
And let me just understand your concerns. Firstly, how would you redraw that parameter plan? So let's look at the comparative baseline. I know the numbers issue. I'll put to one side the numbers issue. Let's assume this is an application for 100 units. How would you redraw the parameters plan?
I would take the built development area closer to the eastern site boundary. Mm-hmm. I would have a more indented built development profile along the western site boundary and a deeper green space at the arrival area.
So more indented on west, and you would lose the east, would you? So it would be salmon going all the way to the boundary, or is it thinner on the boundary?
I would move the development area up to the outer edge of the root protection areas for the citrus trees and other vegetation.
Well, we've currently got a strip of between 9 metres and 12 metres. If you look at Mr. Williams' page 11, we've got a drainage ditch that runs along that line as well, and we've got a hedge line, and we've got root protection areas, and the DAS tells us there's a need for maintenance along that strip. So just so I'm clear, it's shown as being 9 to 12 metres. Nice area to walk your dog around the site, whatever it may be. What are you saying it should be?
I think I'll have to look at the arboricultural impact assessment to answer that. 1 second, please.
I'm assuming you've given thought to this in advance of giving evidence, Mr. Kirkpatrick.
I have indeed, but I can't give you a precise figure without going back to this document, I'm afraid.
Well, I don't need precision, I just need broad orders of magnitude. It's between 9 and 12 metres. We've got a ditch running through it. We've got a hedge line, a mature hedge line running through it with root protection areas. There's a need for maintenance of both ditch and hedge line. And your paragraph 9.1.2, you tell us that the green space in the eastern corridor would have been more effective if it had been concentrated on the western side.
Okay.
So my question is a really simple one. By how much? So when the inspector looks at that, should he be looking at a location where you've got landscape and open space which is gone, which is thinner, which is similar order of magnitude? I mean, I genuinely do not understand your case in relation to this.
Okay, well, I would suggest approximately 5 metres. So what
Half
you
the
have,
width then.
5 metres.
So some green space on eastern side, but about 5 metres. Yep.
That's what would be required to retain that ditch hedge with appropriate tolerances for maintenance.
And we can note, can't we, that say for 9.1.2, where you say the green space in the eastern corridor would have been more effective had it been concentrated on the western part, you don't give us any precision as to that proposition, do you?
I do not.
And you can turn it up if you want to, but it's paragraph 43.3 of the Statement of Case of the Council, which tells us the proposed development doesn't provide an appropriate transition between the bulk settlement and rurality to the west due to the density and spread of development proposed. This impact could be further mitigated or avoided with revisions to proposed development. So the first time I get any precision as to what revisions could be made to the parameters plan to make it acceptable on an allocated site is halfway through cross-examination. What do you say about good practice, Mr. Kirkpatrick? Does that comprise good practice on the part of a local planning authority?
I think the local planning authorities go through a process with limited resources, and they've gone through a process of they don't, very few planning authorities have a specialist advice unless brought in on specific occasions. So they make their judgments. and the this is
I'm
bad.
sorry to cut across you, Mr. Kirkpatrick, because I'm not interested in the plea of mitigation. I'm asking you whether it's good practice in the context where the authority has engaged Mr. Radmill to advise and he hasn't said make any revision. The statement of case is produced which says you should make some revisions. Your proof of evidence doesn't give any precision in relation to it, and it's only halfway through cross-examination we get any precision about what revisions could be made to the parameters plan so as to make it acceptable, subject to the numbers point. Is that good practice, mindful that this authority has engaged professional landscape witnesses? Good or bad practice, do you say, Mr. Kirkpatrick?
I don't think it's bad practice, but it could be. That practice could be better.
Could be better. That's a very fair answer, if I may say so. So we can reduce the eastern bit and we buy back a strip of about, well, between 4 and 7 metres along that eastern strip, apparently. No? Mr. Williams can deal with how much it would be in any event. The northern element, you tell us in terms you think it's right that the built form should be broadly aligned with the northern extent of the settlement. I don't take it that there's anything in the northern part of the structural landscape you take issue with on the parameters plan.
No, there isn't. I think it provides an appropriate response in design terms.
If you look at Mr. Williams' page 11, the western boundary, the parameters, the thinnest is 16 metres, the widest is 29 metres by the entranceway. Are you able to give me, without thinking about it on the stand, where you've told us how much more of a set-off there is necessary for this parameter plan to be acceptable? It shouldn't be 29 metres, as Mr. Williams says. It should be ...
Okay. It's not a figure that I provided, but I think the concerns I would have on the 16-metre wide western buffer are that, first of all, there's a tractor access within that, so I think we would need to allow 3 metres for that. Then there is a footpath within the green space, so you would need to allow 1.5 metres for that. Then you need approximately 2 metres offset for both the tractor and the footpath on either side of the green space. That gives another 4, so that's 8.5 metres that's taken up by those factors. That leaves us with 7.5 metres for green space for trees. That equates, to my mind, as a single line of trees. They're going to be they're going to be deciduous trees in accordance with the requirements of the policy, and it's going to be a single line, quite rigid appearance, with winter views clearly showing every house along that western edge.
Oh dear. Can you turn to page 13 of Mr. Williams' evidence, please? You've been to site, haven't you, Mr. Kirkpatrick?
I have indeed.
You've been in the site, haven't you?
I have indeed.
Okay. Page 13. And it's notation number 7 we're looking at there, yeah?
Yep.
And this is taken from page 49 of the DAS, so this is not new material. And we can see the footpath which runs through that area of open space. We can see 2 lines, one of which is a wiggly line, the other of which is a straighter line in relation to the edge of the site. And then do you see in the shadow to the west of the site the existing hedge line?
Yes, I do.
It's utterly wrong, isn't it, to say, as you just said to the inspector, that there would be a single line of trees through which, in deciduous views, there would be direct views of the western part of the site. That's just wrong, isn't it?
No, it's not wrong, because that hedge is 5 metres high. The houses are 9.5. Year 15 vegetation 7.5. So the issue is, what are you going to see above that retained hedge? And the answer is single line of trees with filtered views of the built form to the rear.
Okay, now I really am struggling. Where are you standing for this particular problem to occur? Are you standing in the field where we have the very large polytunnels
No,
Or are
we're
we
looking
standing on
at.
Kenward Road where we've got the very large hedge?
No, I think if we take viewpoint 4C, Hampstead Road, near the country park.
Sorry, I'm looking at the effectiveness of the western side in views from the west.
Yes?
Okay, so whereabouts on the west am I seeing when I'm looking through my 3 lines of trees? If I'm on Kenwood Road, I've also got an oblique angle and I'm looking through a hedge. And if I'm further back in the private field to the west, I've also got polytunnels in the way. So if I'm looking from the west, how is there not an effective screen with 3 lines of trees?
I think my point relates to the southwest, and that is, as I say, the Hampstead Road viewpoint 4C montage.
Well, humour me by answering my question rather than the question you want me to answer. From the west,
From
that
the
would be
west,
effective, wouldn't it?
I have not, apart from the view corridor along Kenwood Road, I have found no harm and don't see that as an issue. As you suggest, the polytunnels on the western side of the site would enclose views of the built form.
So thinking about this point about the depth of development on the west, in views from the west, you're happy with the current parameters plan. Your concern relates to views from the approach on Kenwood Road, that view corridor, and views from much further to the south.
Yes, the southwest.
Right, let's break those down in turn then. Viewer from Kenwood Road. So as I am approaching the site, I've got this area of land in front of the proposed development, which could be planted up with whatever you want. There's 29 metres by about, what's that, 70 metres of land with a road going through it. There's ample opportunity for planting to soften that edge, isn't there?
To soften it, but not to satisfactorily enclose the views such that you don't see the built form from at a long distance along Kenwood Road.
Why do you need to hide the entrance to the settlement? Why is that an objective?
Because that is a reflection of existing character of the village, and it's one of those valued characteristics of the village as set out in the Conservation Area Management Plan.
Well, hold on. No, it isn't. That's the photograph you took us to in your evidence in chief, that you can look along Kenwood Road from the west, looking directly across the site on the straight bit, and you see houses with the delightful polytunnels in front of them.
You see that.
So why is it an objective to hide the entrance to the settlement rather than softening it?
Because it is a valued characteristic of the village that on the approach roads one suddenly comes across the built form. It's the terminology is used in the conservation area appraisal as the village comes into view without any pre-warning, or from the southwest at the last moment the village comes into view. And this is something that is valued in terms of how people appreciate the landscape setting of the village. And my concern has been that that it's important that along that long distance along Kenwood Road, that one doesn't have that immediate and long exposure to the new extent of the village, but it comes into view at near distance and suddenly.
Can you turn to your photograph M, and can you also have out page 13 of Mr. Williams' evidence? Because I really am struggling to understand your point on this one, Mr. Kirkpatrick, and I'm sure it's me. Photograph M on the western approaches to the settlement. At the moment, straight line, I see polytunnels on the site and I see houses behind it.
Correct.
Quite a distance down Kenwood Road, in fact. Do you see that?
I do see that.
So why, in bringing forward development in the location where we see the polytunnels in the foreground, where in future, on your case or our case, there will be houses, why is it a design objective to hide them?
it's a design objective insofar as one wants to minimize the appearance, the prominence of the built form on the approach road and endeavour to make it more of a sense of arrival when at close proximity to the site, rather than opening up new long distance views of the built form. And I note your point that you can see the existing house, but my point is that actually that could be readily interpreted as a farmhouse or something or a building associated with a polytunnel landscape. To introduce buildings, a greater mass of buildings into this view is something I think one should be wary about, and accordingly have a deeper green space that gives greater opportunities for softening and enclosing the built form until one arrives at the entrance.
So let me understand your case then. You accept that the appeal proposals will soften. You think that there should be enough of an open space in that location to enclose, and that will be the objective of the structural landscaping of the 100 unit scheme rather than the 112 unit scheme. That's your case, is it?
It would be an objective of both the schemes. It's more difficult to achieve at the 112 unit scheme because there's less space available.
Let's think about that sense of arrival, the gateway to the settlement. If you look at page 13 of Mr. Williams' evidence, where the blue arrow is pointing towards the southeast, a pedestrian, horse rider, cyclist, motorist who has driven, ridden, walked, cycled eastwards along Kenward Road will have seen the softened view of the built form, however that's been designed, and we see the little stars on there, for some distance along Kenward Road. As he or she turns the corner, they will then see open space on the left and open space on the right as a softened approach to the settlement. Is that an appropriate approach? Is that an appropriate gateway? Because they'll read it as open space on both sides of the road, won't they?
The gateway, there's an area of transition there between what one would appreciate at the site access road and the start of the existing Kenwood Road housing. The fact that you've got open space on both sides, I don't think removes that objective of having a sudden sense of arrival.
Yeah, I'm so sorry. I try to ask precise questions, and I don't want word salad back. I ask you a specific question. Is it an appropriate gateway to the settlement to have well-designed open space in that location on both sides of the road? Because I thought your case was it was.
Yes, it is an appropriate gateway.
So the issue between us is not the approach that's been taken, it's the extent on the north side, not on the south side. Is that right?
That is correct.
And you also haven't sought to quantify by how much more that should be increased, have you?
No.
Right. This big point about the western boundary needing to increase, the western boundary needs to be increased, whether from the views of Kenwood Road or from across the valley. Can you just tell me where that's explained in your evidence? The critical need for the western parts of the parameters plan to increase in size. I know you make the point about the entranceway, but it's the western side. Where's that?
I don't believe I've made any specific reference to that.
Not a word.
Simply the points that there are opportunities to increase the quantum of public realm, thereby achieving a greater feathered edge along the western edge and an increase in a more of a visual mosaic of buildings and vegetation. So it's a general point, not a specific one where I'm am giving a detailed commentary on a parameter plan.
So, we know that the salmon area on this plan, the salmon area includes the play space and the plots for the houses, and also includes the verges and the roads and all the other accoutrements one has within the developed area of a site. Agreed?
Yes,
We also know that it's about 0.02 of a hectare greater than you would have at 30 dwellings per hectare, don't we? 200 square metres, you put it.
yes.
In fact, you're wrong. It's 167 square metres, but I'll put the maths to your colleague. So we know, broadly speaking, it's only a little bit bigger than it would be for a development of 100 units at 30 dwellings per hectare. Agreed?
Agreed.
If this parameter plan was proposed for 100 units, would it be acceptable?
I think it would certainly be more acceptable. Without seeing the detail as it's laid out in an illustrative layout, it's difficult to answer that question.
You've crawled all over these illustrative layouts, and one could recast the illustrative layout by not dividing up plots, so getting a density which is precisely 30 dwellings per hectare and 100 units. I'd like a precise answer to a precise question. Is it your case that this parameter plan, this one that's before the inspector, would be acceptable for 100 units, and it only becomes unacceptable for 112 units?
I can't answer that question because there are other factors in that. It's not simply a question of numbers of units. It's about density and the success or otherwise of a layout.
So you don't know?
I think I wouldn't want to make a judgment without seeing a scheme.
No, I understand. I want to be clear. Based upon the information you have at the moment, you don't know. Is that fair?
I don't know 100%.
So you don't know 100%. Well, what about making a judgment? So I'm not asking for certainty. Would it, in your judgment, be unacceptable for that parameters plan to be brought forward for 100 units?
I think it would be more acceptable. That's as far as I can make a judgment. More
acceptable, but you don't know if it's acceptable. Does the site have capacity for 100 units?
Could you repeat that?
So, it's all right, we're fighting with time. Does the site have capacity to accommodate 100 units? Approximately 100 units?
I think I think the answer would be yes.
Good. Capacity to accommodate 100 units.
But without seeing a layout based on 100 units, it's difficult to know how successful that layout would be.
Good, that's helpful. So you accept it has a capacity for about 100 units. This is a site which is allocated in a recently adopted local plan, isn't it?
Correct.
Thank you. Now, you did an exercise in your evidence in chief that I just want to explore momentarily, if I may, which was based upon average plot size. And I just want to understand the sense of that. You told us that based upon 30 dwellings per hectare, that would amount to 333.3 square metres per house, looking at what the inferred net developable area would be. Do you recall that?
Yes, I do.
And then you told us that at 33.4 dwellings per hectare, the inferred plot size would be 29.4 square metres, and that gave you an overall difference in terms of the plot size comparison of 3,796 square metres. Essentially, you would have more open land if the houses stayed the same size because you'd have bigger gardens, bigger plots, yes?
Yes.
So when you were talking about open space throughout your evidence in chief, you were talking about the open space within plots based upon your exercise, weren't you? Because that was your starting premise.
When I'm talking about green spaces within my evidence, they are either peripheral green spaces or internal green spaces.
Your starting point is nonsense, isn't it? Because at 30 dwellings per hectare, that would include not just the houses, not just their gardens, but it would include the roads, the verges, the peripheral trees, the pocket parks, everything else you get within the net developable area.
Correct.
The figure of 33.3 square metres per house is just, it's non-helpful. It doesn't reduce prior uncertainty, does it? It's not that there's an extra 33.9 square metres per plot that you could shave off, because these are not plot sizes, because you would have lots of other bits apart from just the plots and the houses. Do you agree?
I agree that that figure I've given you didn't take that into account.
Yeah. Whatever the figure actually is in terms of plot sizes, it is likely to be significantly smaller than either 333.3 square metres or 299.4 square metres. Do you agree?
Could you repeat the question again, please?
Whatever the difference in whatever the plot sizes will be of the 112 scheme that's before the inspector or the 100 scheme that you've assessed on that analysis, the plots are going to be much smaller if you're taking out of that overall figure the roads, the verges, the hedgerow trees, the pocket parks, all the rest of it. It's going to be smaller, isn't it?
Yes, that's correct.
Thank you. In terms of the exercise where there is a comparison between what the inferred developable area is, i.e. the salmon pink bit, between a scheme of 100 units at a density of 30 dwellings per hectare and 112 units at 33.4 dwellings per hectare, it is 0.02 of a hectare, isn't it?
Correct.
Or rather, it's actually 167 because it's 3.33 recurring, but it's of the order of about 13 or 14 metres squared, isn't it? About the size of this room. That's the difference in terms of coverage, to use the words of the reason for refusal.
Yes, for that factor, yes.
So if that's right, the issue is not coverage, is it? The issue is density that's between us.
That is the primary issue, yes.
Yeah. Because coverage is almost the same whether you're dealing with 100 at 30 dwellings per hectare or 112 at 33.4 dwellings per hectare. Yeah?
Yes.
Yeah, good. Thank you. That's helpful. So the real issue between us comes down to the issue in terms of quantum, doesn't it? I.e. the second of the words within the reason for refusal. Do you agree?
Primarily, yes.
Now, you spend a good deal of your time in your proof assessing the effect of 112 units as proposed against a greenfield site. And I understand that because the site is currently a greenfield site. So, for example, all of your 8.4 does that. Can we agree that the meaningful exercise that the inspector should assess is the one you did in your evidence in chief, which is assessing the effects of a development of 112 units based upon this parameter plan as against approximately 100 units, consistent with the allocation?
Yes, insofar as it takes into consideration the wider effects that apply to the allocation of approximately 100 units at 30 dph. All these issues also apply. That's why for the issues that apply for 100 units also will apply to 112 units, but it's the accentuation of it or the relative difference between the two. So it is relevant in the proof, I believe, to describe the landscape and visual effects. But that is kind of the baseline.
Well, the important information that the inspector needs to take away from your evidence and Mr. Williams' evidence, and that Mr. Ross and Mr. Scott need to take away from your evidence when forming their planning judgments as well, is what the extra over effect would be of 112 on this parameters plan, as opposed to about 100 or approximately 100 at 30 dwellings per hectare. That's the important question, isn't it?
It is.
So when I looked at your evidence, and when Mr. Williams looked at your evidence and sought to identify where do you with precision take that extra over effect and analyse it in your written evidence, I think he identifies, and it's his footnote 7 of his rebuttal, 3 occasions where you identify what that difference is. It's your paragraph 8.4.1, 8.5.2 and 8.5.15. And you say greater opportunity for open space, looser arrangements of building, diminished sense of place. Yep.
Yep.
That's it, isn't it? That's the extent of your analysis in your written evidence.
That's correct.
Well, let's look at these points in details. Greater opportunity for open space, green space. That's the extra 0.02 hectares, isn't it?
So which paragraph are you, please?
Sorry, this is your paragraph 8.4.1.
8.4.1.
Yeah.
Okay, so this is a statement that states that conveying that would be greater opportunities for green spaces and additional tree planting within the built development area.
Yeah. There's nothing in the reason for refusal alleging inadequate green space, is there?
No, the reason for refusal focuses on the dominant and urbanising effects, and in the effects are more urbanising when green space is reduced or insufficient is provided.
Yeah, and we've looked at that insofar as they relate to having smaller plots. So in other words, buying some additional public locations, you'd have to be reducing the size of the plots from the 300 from the 100 unit, wouldn't you? On your analysis. Because we give you the 167 square metres in relation to the net developable area being smaller, you would have that 167 square metres to use somewhere else. But your point about, well, if it's a smaller density, then I've got a different opportunity. You'd either have to have smaller gardens, or rather you'd have to have smaller gardens, wouldn't you? You'd have to buy off something from the plot space, or wider public spaces.
There may well be a reduction in plot sizes for some of the units, but it's a balance between plot sizes and the public realm.
Let's have a think about that. Your second point is looser arrangements of buildings. Can you take up the illustrative master plan, please?
I have that.
So this is drawing number 306. Density, or derived density, is the number of units, isn't it?
In a set area, correct.
Within a set area.
Yes.
In terms of looking at this illustrative site layout, to get to 112, that depends upon the size of the units and the subdivision of those which are terraces or semis, doesn't it?
It does.
And one could recast the built form of this illustrative master plan very easily with a rubber and have almost exactly the same built form and plot sizes, but have it down as about 100 or 105, whatever approximately 100 means. Couldn't one? Because it's a function of the number of units, not their size. Agreed?
It's both size and numbers, because that feeds into the to the footprint of the development.
No, the resultant density, because we have to have, as Mr. Ross will explain later on, that we've got to have 30 dwellings per hectare, and indeed the policy for this site says about 30 dwellings per hectare. Density is a function of the number of units, whatever their size, against a given area, isn't it?
It is.
Yeah. So one could have the same built form, but bigger units, and result in this exact same layout be 100, couldn't one?
Yes.
The important thing is that we are dealing in this appeal with a two-stage process, aren't we? This is an outline application where layout, design, landscaping are not for determination at this stage. Do you agree?
I agree, but I think there has to be a caveat, and the purpose of applicants putting in both a parameter plan and an illustrative layout is to demonstrate the feasibility of a scheme within the fixed parameters. And it seems to me that, and we've had various layouts being presented to the council, many of which have a lot of similarities. And it seems to me that the density is such that the options available are quite constricted. And so and yes, it could be tweaked, but I think the history of this application has shown that it's coming up with very similar results.
Yeah, I'm not actually concerned at this point with the history of the application. I asked you a really simple question. This is a two-stage process, isn't it?
It is a two-stage process.
And the assumption the inspector should work with is the council will do its job properly in the event the appeal is allowed. Do you agree?
I agree.
The council's not bound by this layout in the event the appeal is allowed, is it?
No.
If it considers that there is a need for smaller units, greater planting, smaller plot sizes, that would be a matter that would be open to them, wouldn't it?
They could certainly propose that.
It would be open to them, wouldn't it, to the council to say, bless you, to say that in the event, bless you again.
It would be open to the council to propose that, yes.
Well, not just to propose it. If the council thought that a layout did not give rise to adequate planting or open space beyond the houses, then it would be entitled to refuse it, wouldn't it?
It would, and then presumably, but I think at the back of my mind is the position that the council, through its pre-application inquiry advice, has consistently advised on reduction of numbers, but that has not been accepted, and hence we are at appeal. It may be that a similar process arises at reserve matter stage if this appeal is allowed.
That's an answer to a different question. The inspector should work on the assumption that the council will do its job properly at reserve matters with regard to road layout, footpath layout, internal landscaping, design, plot sizes. Do you agree?
It will endeavour to do its job properly, and I suppose the question is it how feasible it is to achieve what the objectives that it sets?
And the sole question for the inspector at this stage is whether, in principle, it will be possible to get 112 units on this particular size. Agreed?
Agreed.
The detail, the back-to-back, the privacy, the where the road goes, etc., that's all up for the next stage. It's up for the inspector to assess whether the principle could be determined at this stage. Do you agree? That's what an outline permission is.
I agree that that's the inspector's judgment.
And what counts is not the numerical density, it's the actual disposition of the built form, which is actually not before the inspector at this stage. Do you agree?
The distribution of the built form is set out as the current option in the illustrative master plan.
And what's the answer to my question?
Sorry, apologies.
The distribution and design of the built form is not up for determination at this stage, is it?
It's not up for determination at this stage.
So your case must be that in principle about 100 is okay, but 112 is not okay. That has to be your case, doesn't it?
It is correct.
Mr. Scott will tell us, because he says so in his evidence, that approximately means above or below 100. Do you recall that?
Yes, indeed.
He also tells... Sorry. So
my answer was given in the context of the statement from Mr. Williams, where he said, apologies if I've misinterpreted him, but for the purpose of this appeal, we're assuming it's 100 units.
No, the allocation is approximately 100 units.
Yes, okay.
And we're told in the council's statement of case and in Mr. Scott's evidence that could be above or below.
Yes.
It depends upon demonstrating that that's above or below is acceptable. Yeah?
Correct.
But he also tells us that 112 or plus or minus 12 is beyond what he thinks is approximate.
Correct.
And there's an issue between himself and Mr. Ross on that one.
Yes.
But plus or minus something is acceptable, but it's less than 12%. Yeah?
Yes.
And he also tells us less than 10%. Okay, so let's assume he's right. So the allocation means plus or minus something, but it's plus or minus something less than 10%. Let's put 5%, okay?
Okay. I think there's two...
Are you with me so far?
I'm with you.
Good. So let's pick a plus or minus 5% is what approximately means. He may say 3% or 7%, who knows? But let's assume that's the case, that it's plus or minus 5%. He also tells us that if you're not in accordance with approximately 100, that you're contrary to the policy and unacceptable. So whatever is the plus or minus figure that the authority believes is the approximate issue, subject to the inspectors agreeing with us rather than Mr. Scott, we know that not less than whatever that figure is would be unacceptable, don't we? So a scheme for, if it's plus or minus 5%, then a scheme for 85 units on here wouldn't be acceptable because it's not been developed in accordance with allocation. You follow that?
Yes.
So your approach, as I understand it, has been to say, well, let's take the middle number of 100. Is that fair?
That's fair.
What Mr.
Yes.
Williams has done. Yeah?
Yes.
Good. So when the inspector comes to test your points, which you make with passion in your evidence in chief, about 100, you can achieve these various objectives and render the development acceptable, but 112, it cannot be acceptable based on the information you've seen. Does that hold good for 105 as well? Is it unacceptable anything above 100, or is that not something you've even thought about?
I've certainly thought about it, and
Good.
I think that it very much depends on the specifics of the illustrative scheme, whether that works or not.
Right, so 105 could be acceptable potentially, because that
Potentially.
would allow that fantastic word, interstitial or gap planting, yeah?
Potentially.
But your case is at 112 you couldn't achieve that.
Correct.
So when I look at, if you forgive me for a moment, Mr. Williams' evidence again, and his page 13, where he does illustrate from page 49 of the DAS the sort of planting that one could achieve in and around the appeal site. Not acceptable at that, but would be acceptable with 12 fewer units, or even acceptable with 7 fewer units. That's your position, is it, Mr. Kirkpatrick?
I think it's not solely a question of the illustrative landscape proposals. It's a question really of the numbers and the density of the units. So the knock-on effects of those numbers on the appearance of the area.
But we just agreed that density of itself is not determinative. It's how the built form is disposed and the ability to have planting between. You could scrunch up the ones in the top right-hand corner into 3 units, and they'd have the same built form, the same plot areas, and it would be a wholly different density. It's the extent of built form which is up for grabs at the next stage. Do you see the point, Mr. Kirkpatrick?
I do.
Yeah. And your case is you can do that at 100, but not at 112, despite the fact the built form is not up for grabs at this stage. Do you see the difficulty of your case?
I do.
Yeah. So I'm almost done, but it would be useful perhaps to take the mid-afternoon break just to review my notes, if I may. That will be fine, sir. Thank you. Thank you, sir.
can resume. Mr. Tucker.
Thank you. Good afternoon again, Mr. Kirkpatrick. Rest assured we're nearly there. Right. Next process. Let me give you a couple of scenarios and let's see if we agree with it. One might have a rotten LVIA, a terrible design access statement, which then leads to a scheme which is otherwise excellent. That could happen, couldn't it?
It could.
Or one could have a fantastic LVA, a fantastic DAS, great process, but leads to a rotten scheme. You may have seen one or two of those.
I agree.
Yeah. Ultimately, what matters is the outturn of the exercise rather than the process as an end in itself, doesn't it?
It is.
Let's think about the policy in that context for an outline application. Can you turn to your paragraph 1.2.2, please? So, we are dealing with here a two-stage process where what's for determination is the principle of development and then detailed consent for the vehicular access into the site. Issues of scale, appearance, layout, design and landscaping, subject to the parameters plan, are for the determination at the next stage. Do you agree?
I agree.
If you look at the criteria of the policy, which you helpfully set out at 1.2.2, let's just think about how criterion 5 informs the process. Because so far criterion 5 has been directed specifically at this stage, but let's have a think about it if the appeal is allowed. Criterion 5, the layout and form of the housing element shall be informed by an LVIA and incorporate both boundary and internal structural landscaping that responds to the site's topography. So when considering scale, design, appearance, layout of the housing element, that will necessarily have to be informed by an LVIA. That probably means further LVIA work for Mr. Williams if the appeal's allowed. Do you agree? The next stage is as informed by an LVIA as this stage is. Do you agree?
I agree.
And similarly, in terms of landscape, structural and non-structural landscape, that would have to also be informed by by an LVIA to conform to criteria number 5. Do you agree?
I agree. The question is the robustness of the LVIA and whatever that constitutes.
Yeah. But if the appeal is allowed, the inspector has a degree of comfort with the council, as we've agreed will do their job properly, that the second stage of consenting will be informed by exactly the factors which are described in criterion 5, i.e. LVIA work. Do you agree?
I agree.
Good, thank you. In terms of the allocation, this is a point really we'll be picking up again tomorrow with Mr. Scott, but in terms of the allocation, at the time that the inspector was considering his report into the emerging local plan last year, and earlier this year in fact, the landscape character assessment that you referred to was in existence, wasn't it? In fact, it was an evidence-based document for the local plan.
I'm not aware of the dates, so can't answer that.
Okay, well, I can certainly ask Mr. Scott if that's disputed. It's actually in the local plan examination library if you want to check overnight and then come back if I'm incorrect. The conservation area appraisal on its face is a 2021 document, so that plainly predates the allocation and predates the examination, didn't it?
It does.
Heritage isn't a reason for refusal in this case, is it?
No.
So if I'm right about the LCA, then the proximity of the area of local landscape value and the conservation area and the nature of the settlement and the change in density inferred by the policy were all known to the inspector and the local planning authority when the site was allocated. Do you agree?
If those dates are correct, yes.
Now, at 3.1.1 of your evidence, you tell us that the site is physically in the countryside. And in common parlance, that's exactly how most people would describe it. Mindful that it's got polytunnels on site A and it's open land on site B. In policy terms, it's not though, is it? It's part of the settlement.
Correct.
And in terms of forming a judgment, in terms of impacts, the inspector should be aware of, shouldn't he, in terms of your area of expertise, that the appeal site is part of the settlement and not in policy terms part of the countryside. Do you
Correct.
agree?
Yes, agreed.
Thank you. Oh, sorry, just one final point as well. You said in your evidence in chief, in fairness to you, just quote the words back so I'm accurate, that at 30 dwellings per hectare, that would be a big difference in terms of the allocation compared to the density of the existing settlement. Do you recall that?
Yes, I do.
And your point there is, because of the imperative to use land efficiently, as we are told to by national government, which again we'll talk about tomorrow, because of that imperative, it's not unexpected that new development will come forward at a higher density than adjacent development, is it?
Agreed. I think there's a judgment, as you say, between the need for housing and the need to conserve environmental resources, avoid harm, etc.
And let's just bring it all together so that hopefully everyone will find that I've not wasted everybody's time this afternoon. Ultimately, the differences which lie between yourself and Mr. Williams are matters of judgment, aren't they?
They are.
Best resolved on site by the inspector.
Correct.
Probably should have asked that at the start. Thank you very much indeed for your time. Thank you, sir.
Well, thank you. I don't have any questions to follow up there. We'll do the re-examination.
Thank you, sir. A few from me, about 5 minutes.
Yeah,
Okay.
5 minutes.
We'll just go straight through. We've had a short
Okay,
break.
yes.
Let's go, please, back to your proof of evidence, paragraph 8.5.16. Yes, 8.5.16, page 37, PDF 38. Mr. Kirkpatrick, you set out a number of bullet points at your 8.5.16. In light of that, how clear was it in your view what your concerns were about the LVA?
This sets out a range of concerns about the LVIA, about whether it's understood and teased out the susceptibilities of the local landscape, and whether or not it's teased out the effects properly on visual receptors. And these are important insofar as they relate to harm and this goes back to my earlier point about the issue is the difference between the harm that arises from the allocation and policy as opposed to the harm that arises from the appeal scheme.
Go please to CD 13.1.
Core document 13.1.
Correct, yes. Look at paragraph 1.5 on page, it's internal page 1, PDF page 3.
Okay, 1.5.
Read that to yourself, please, and once you've done that, turn forward to paragraphs 5.2 and 5.3 on final page and read those, please.
Okay, I'm now at 5.2, 5.3.
Yeah. In light of what Mr. Radnall tells us about his instruction and his advice to the council, to what extent was it his role to advise the council on whether or not the parameters plan was acceptable by reference to the relevant development plan policy?
Sorry, could you repeat the question?
Yeah.
It's not
To what extent was it his role to advise the council whether the parameters plan was relevant by reference to the relevant acceptable, sorry, by reference to the relevant development plan policy?
It wasn't part of his brief. His brief was to review the LVA.
Same question with respect to density. To what extent was it Mr. Radmore's role to advise the council as to whether the density was acceptable by reference to the relevant development plan policy?
Again, not his role.
Have you considered the relevant development plan policies in your evidence?
Have I considered the pardon?
Have you considered the relevant development plan policies in your evidence?
The policies, yes, I have.
And have you formed a judgment on the extent to which you consider there to be compliance or not with those policies in landscape and visual terms?
Yes, I have.
Thank you. So that's everything from me.
Could I just check out of abundance of caution, and I do so not suggesting there's a point here, might I have sight of Mr. Radmore's brief in the light of that re-examination, please?
Yeah, can do. If we can get hold of it, that's fine. Yeah. I haven't seen it myself.
I'm sure the council will have it if it's in writing, but in the
I'd
light
like
of
to
that
hope so.
re-examination,
I'd like to hope so, Mr. Tucker, but all I can say is we'll look for it, and if it's available, I'll provide it to you. That's absolutely fine.
I'm grateful for that, but it's been led that this is not part of Mr. Radmore's brief, so I'd like to see it, that's all, as an abundance of caution.
I mean, my answer is before, so if it's available, I'll provide it. That's fine.
Draws matters to a close for today.
Yep.
If anyone's happy with that. Tomorrow, we can always start at 10 o'clock. Is there any particular merit to starting earlier? Or are we happy we're going to be able to fit in comfortably within the time we've got available?
So given that we're rising early this afternoon, it would be helpful, I think, to perhaps start at 9:30 if that's acceptable. I'm just thinking about your site visit on Thursday. I don't want us to get to the point at Thursday afternoon and it's 5:30 and you'll want us to get out on site.
I've got Wednesday here, we've got essentially a little over 3 hours, or just short of rather 3 hours in the morning, and then rather longer afternoon in that. So sometimes it's easier to squeeze in the morning rather than in the afternoon. Do you think that's going to be helpful? To start earlier, or is that going to be?
30 takes us through sort of 10, 15, short break, 10:30. Will make some difference. Quite whether you think it's massively used there, but we can facilitate 9:30. The only thing I say we obviously can't do before 9:30 is access is only at 9, so I think being realistic.
There's no point being any earlier than 9:30. No, fine.
I only say that because Mr. Carver and I spent a week starting very early on a morning, and that's not going to be possible.
Okay. I think it would be helpful just to allow us to have perhaps some slightly more breaks, slightly longer breaks than we had today, just so that we're doing comfortably in on what otherwise is quite a full day. Okay.
And so please don't misunderstand me. It's my point about breaking early is not unhelpful, because that way Mr. Scott and Mr. Ross can have a conversation about conditions and hopefully come back tomorrow with a white smoke coming from the College of Cardinals.
Still compliance schedule's all been taken care of, sir, so we'll get, I think that's been sent across to the case officer, but do you want a hard copy, because it might be slow to make its way through to you?
On the conditions that like some compliance things, if I can get a copy of it sooner rather than
Okay.
just to give me the longest opportunity to actually have a look at it. I am aware the case officer is not at work tomorrow. Others are meant to be monitoring this.
Fine. Well, we will bring a hard copy in the morning for you, sir.
That's
absolutely fine.
I will get it, and then we'll be delayed a bit.
Yeah, no problem.
Yes. Do you have a particular deadline? I would like mine as soon as possible.
No, I think the objective is tomorrow as well, as I understand it.
Yeah, well, firstly, I'm sure that we can email, as we promised this morning, whatever the state of the conditions are now, and that can be just sent on a basis of allowing us to make a start, and then those will be superseded tomorrow once Mr. Ross and Mr. Scott have had a further conversation, if that's acceptable. Thank you, Mr. Brown.
Thank you. Okay. Rather early, 3:15. We can adjourn there until 9:30 tomorrow morning. Thank you, adjourned.
Thank you, sir. Thank you, Mr. Kirkpatrick.